Do it again?
Should I do it? Just leave it where it is.
Okay.
Except do the VGA part of it. Someone can kick that connector underneath out. That's because this isn't connected.
No. Oh, that would help.
I mean, it tend to.
There we go. Thank you very much, sir.
You're welcome. Yeah, we just have to connect the train together.
It helps to plug it in, doesn't it?
Can they not? They got that. Very small rocks. See his thing up there? It's got Monty Python. Okay.
All rise. Oh, yes, yes. The Honorable Superior Court of the County of Germany now opening the seat with discussion of students. The Honorable Orlando Hudson Jr., Judge presiding, God save the States on the court. You may be seated. Make sure your cell phones are turned off or put on vibrate. Your Honor.
Hello. These books are. No, I don't need books. Are these for me this time? Oh, there's something else. What is this? That's nothing. All right.
Can I approach the 10 seconds, Your Honor, please?
Yes, Mr. Reed.
Thank you.
I see your name on here. What do you want? You and Mr. Dornfree? Where's Mr. Dornfree? Huh? Can I give you an idea? I cannot. Maybe Miss Ellis and the defense team can tell. He wants to know when we're going to hear his case, Miss.
Excuse me?
Mr. Reed has a case on here with Mr. Dornfree. He wants to know when he can hear his case.
Your Honor, I believe that the
Which is a
calendar
legitimate
call is being handled next door. Oh, it's his case? I do not know. I apologize. I do not know.
I'll check back to 2:30.
If I had to forecast, Your Honor, we're going to be here for at least a couple of days.
All right, Mr. Reed. All right, counsel, what are we here for today?
Your Honor, I think that's an excellent question, a good place to start. We have two pending motions. One is a motion for new trial based on DNA. And one is a motion for a new trial based on the motion for appropriate relief. When we gathered in chambers in June, the state expressed a preference for doing the motion on the DNA motion first.
Right.
So it was our thought that we would do that first, but there are a couple things related to that. There may be a couple of witnesses called, for example, in the DNA hearing that would also testify in the MAR hearing. And so what we would suggest, if it's all right with the state, is that those witnesses who are dual witnesses for both hearings be permitted to testify kind of all at once, so we don't have to call them back twice. And we can, if it's easier for the state, we can denominate, all right, here's the DNA portion, let them cross-examine, and then get into matters beyond DNA separately. So it's plain that we're in the motion for appropriate relief portion. And I don't know how the state feels about that, but that seemed to be the easiest way to handle the logistics rather than having to call people twice. I think the other issue, of course, is all of the DNA evidence is also part of the motion for appropriate relief evidence. So we're going to ask the court to take judicial notice of the evidence presented in the DNA hearing for purposes of the MAR hearing, so we don't have to put it all on again. And I don't know if that makes any sense, but I will let the state respond.
Your Honor, it's our position that the DNA evidence in this matter under both 270 and the MAR are irrelevant, immaterial, and not favorable to the defendant. I would ask that the two hearings be separate. They're dealing with two separate issues, and the DNA under the Court of Appeals, when they returned this for hearing, they stated the DNA portion was improperly brought under the MAR. So therefore, they're attempting to bootstrap the importance of this DNA with other evidence that doesn't corroborate, it doesn't match up, there is no linkage. And Your Honor, to allow them to attempt to muddy this and to smash this into one hearing, I think would be a disservice. So, Your Honor, we'd ask that if we have individuals who will be testifying in both, they need to testify separately for each separate hearing.
But if obviously I can't make the state agree that, I thought it might be a way of saving time, so we didn't have to chase people down twice, but obviously I think it's within your discretion. I think the court's more than capable of keeping separate evidence relating to the DNA and evidence relating to the motion for appropriate relief, and at least I'm not worried about confusing the court. Although as we go through this, you may accuse me of that, and also I'll apologize in advance. But I think, you know, we can easily separate it out. I think it's more efficient. We don't have a jury. Your Honor is the finder of fact. So however Your Honor wants to proceed, we will proceed on that. But we do believe very strongly the DNA evidence is also going to be part and parcel of the MAR evidence. And she didn't address the second part, but I'm assuming she's not going to require us to put on all the DNA evidence again in the motion for appropriate relief hearing.
Well, I don't see her making an effort to make it easy.
Well, we're prepared to proceed however.
I think the Court of Appeals, I don't know that they said you couldn't do it. I think they said that you couldn't do your DNA test hearing as a part of your motion for appropriate relief. You had to file another motion, which you did, but I don't know that the judges on the Court of Appeals were thinking necessarily who would be testifying for what portion of it.
I totally agree, Your Honor. And I think that the main reason we had to file a separate DNA motion, the Court of Appeals acknowledged the DNA was part of the motion for appropriate relief. But they said we could not get relief separately for the DNA under 15A 270 and 269 because we had to have a hearing specifically on 269 and 270. They never said the DNA wasn't part of the motion for appropriate relief.
Well, she said her position is that it was irrelevant. I actually thought the opinion of the court said that the defendant raised some very relevant issues about DNA and other matters throughout the course of what turned out to be a futile motion for appropriate relief. But even the Court of Appeals indicated that there were some very pertinent points raised by the defendant.
That is correct, Your Honor. And I've actually brought an extra copy of the opinion.
Oh, I don't need to. I know what it said. And I don't think it's going to be very difficult to separate.
Your Honor, we have-
But let me ask you this. Don't you anticipate the statutory, dealing with the statute, with the DNA, you can get through that fairly quickly though, can't you?
Well, I'm not sure. I'm not sure how much cross-examination they have. We've gotten their witnesses, so I'm not sure whether that's for DNA or for motion for appropriate relief. The DNA is more than just the DNA, because I think, as Your Honor has seen from the papers, the DNA led to a codicil, which then led to an individual named Jermac Jones, which then led to an interview, which then led to some statements, which then corroborates a confidential informant memo, and that's all part of favorability we would contend under the DNA statute. So it may take a little bit longer than just simply hear the DNA results. Are they favorable? You know, are we going to argue about whether they're favorable or not? I think you have to see where the DNA, what evidence the DNA results led us to. So because of that, I think it takes a little bit longer. I think it'll probably take. We've got 3 experts and several other witnesses about the DNA piece to present. So we could be here today and into tomorrow on the DNA.
It says he says it's not really, he can't really separate them as clearly as you would like him to. That some of them's going to overlap.
I understand that, Your Honor. These are very complex issues. However, I believe that we need to take these 2 separate matters, and so that we can clearly keep these on record for any type of appeal. And I think that the cleanest way that we can separate these 2 issues is to have 2 separate hearings.
Your Honor, I probably didn't make myself clear. The favorability evidence that we're going to put on where the DNA led, we think is properly part of the statutory DNA here. Every bit as much as it's part of the motion for appropriate relief. Because the statute says the court's got to determine whether the results are favorable to the defendant. Yeah. And the state argued on appeal, and I think...
Well, I think it's interesting that she's going to argue that there was nothing favorable about the DNA. I think that's interesting. So...
I do too.
Actually, what's the definition of favorable?
Well,
I wonder what the legislature meant when they said favorable.
Well, the short answer is nobody knows because it's never been litigated.
Yeah.
Now, what the state argued on appeal, and I tend to agree with them, is we know what the highest standard is. And the highest standard would be the same for motion for appropriate relief, which is would a reasonable jury have a reasonable doubt about the defendant's guilt in light of the DNA evidence. It certainly means no more than that, because that was what Your Honor had to find in order to issue the motion for testing anyway. So it makes some sense that the standard that you use to issue the motion for testing would probably be the standard that you use for favorable. Although you could argue favorable may mean less, because if they had wanted to say the same thing, they could have said the same thing and they said favorable. But it certainly means no more than would a reasonable juror, hearing this evidence, have a reasonable doubt about the guilt of the defendant. And we would bear the proof of that by preponderance of the evidence.
I don't think I'm going to have any difficulty separating the two issues. I think the court reporter is not going to have any problem doing that. I don't think the appellate court will have any problem making decisions about what we are trying to do. They didn't have any problem the last time you all argued to them. They had their own view about how things might go.
They did, Your Honor.
Yeah, I'm ready to go.
All right. We have two other administrative matters. Your
All right.
Honor signed a subpoena for us. The subpoena due is taken to the Department of Social Services for certain files. A representative is here for that. We'd like to address the court on that.
All right, yes, sir.
Yes, Your Honor. Rob Marchenek, Durham County Department. I'm representing Durham County Department of Social Services. I'm with the Durham County Attorney's Office.
Yes.
I did receive a subpoena. I'm attempting to respond to that. Your Honor, under 7B302, I do need to deliver those to you for in-camera review. And the court must determine that they are relevant, necessary, not available from any other source. Your Honor, I'd ask that the court, again, these are confidential records of the Department of Social Services. They can only be released by court order. I'd ask that Your Honor maintain the confidentiality, and if Your Honor does determine that they need to be released, that they be limited in their release.
And that'll do what?
Be limited in their release.
The defendant would have no objection to that, Your Honor.
And that normal range or limit would be?
Your Honor, to the counsel and attorneys and useful for the purpose of this hearing.
Yes. I intend to do that.
Thank you, Your Honor. Your Honor, if I may approach?
Yes.
To provide these for you for your in-camera review. Your Honor, the subpoena specifically stated that it was records and reports related to the Nishonda and Doris Washington in 1991. I do have some records in response to that. Your Honor, in addition to that, I located records that were not directly related to that, but a review of the incidents as basically an interdepartmental review of what happened in that circumstance. It's not directly related to the investigation, but it is more for the purposes of because there was a death involved, the department has to do a review on those. So, Your Honor, I would argue that that's not relevant, not necessary, but I do have it available to submit to Your Honor.
All right.
And that's the second.
All right, thank you.
Thank you, Your Honor.
Your Honor, the other administrative matter is we, at the Sheriff's Department, subpoena an individual named Jermac Jones, who you'll hear more about as we go through the hearing. For my information, Mr. Jones is here. He's outside. We spoke with him very briefly, and he would like to be represented by a lawyer. And we think under the circumstances, that request should be directed to the court. And that given what's going on in this case, that may not be a bad idea for Mr. Jones.
Mm. Well, I don't have any problem with that. I mean, isn't there an issue about the likelihood of him being charged with some event out of this?
Yes, I spoke to him.
I understand that there's no statute of limitations on murder.
Well, also, Your Honor, in the course of the videotape of the that we received through your good offices now, 5 years after it was recorded, he also admitted to the crime of statutory rape, for which there is no statute of limitations in the state of North Carolina. So when I just spoke to him out in the hallway, he said to me, well, don't you think I need a lawyer? I don't want to be incriminating myself. And I said I would talk to the judge about getting him a lawyer. He's sitting right outside. He says he can't afford one.
Mm-hmm. Well, you know, of course, I've been involved in this case, and I read all that material. But I take it I'm not the only one that read it. I take it prosecutors read it. And he's walking around a free person. Mr. Howard is in prison. I'm wondering the likelihood that the district attorney's office or the attorney general office, is there some conflict nature? What's the likelihood of them doing that?
Well,
Of course, I'm asking you. I understand that you're not the prosecuting
well, I think
entity.
one of the things that's happened during the course of this case, and new information has come to our attention, I think that there's always hope for our colleagues on the other side, or as you say, the Attorney General's office, but I think a lot more is going to be known about the relationship between the New York boys and this murder. It was the defense theory in the case that members of the New York boys committed this crime. We now have DNA from Doris Washington that comes from this young man in the hallway, who, as you saw on the tape, is saying, I never knew Doris Washington. I never had sex with Doris Washington. I did commit the felony of having sex with her 13-year-old daughter. If I personally believe that if they actually went to the people from the New York boys who are in federal custody, and actually he says a number of times on this tape, I don't want to rat
Your Honor,
anybody
at this time,
out.
I would
wanna
object
get a
to him
lawyer.
kind of putting out all of this information that's not going to be relevant. It's not going to be able to
Not
come in, because this tape, as you have read, clearly shows they're taking a DNA sample, and he clearly invokes his right to counsel. Clearly invokes his right to counsel, and right now he's trying to get in information about this, that he has clearly invoked his right to counsel, and now he again has clearly invoked his right to counsel. So the state would be not able to introduce any of this tape, and he is not able to introduce any of this tape. Your Honor, I'd ask that if we want to put Mr. Jermac Jones in here and get him a lawyer, let's do that.
Well, I thought that's what he was trying to do.
Your Honor, I
Yeah.
have no problems with that, but like I stated, he's trying to get in information that is not part of this trial.
Well, ironically, I think that they may say that he volunteered it and it wasn't the subject of questioning, but that would be for a prosecution of Jermac Jones. But that has nothing to do with us. That tape and that evidence and those statements that he made that we contend are false exculpatory statements are very relevant and are favorable evidence that corroborate the defense case here, that it was not Darryl Howard who committed these crimes. It wasn't one person that committed these crimes. It was more than one person that committed these crimes, because we have semen from Jermac Jones and Doris Washington, and we have semen not from Jermac Jones, who claims to be the boyfriend, or if that's going to be their theory, but from another person, from a young woman who just took a shower. I mean,
Your
we
Honor.
have our case. It is perfectly admissible. We'll do that. I'm just acting as an officer of the court. The young man is outside there. He's admitted to one crime. I think he should get a lawyer.
I understand that we got numerous issues that could come up, and I understood that. I was simply trying to address whether or not you thought it was even remotely possible that some entity would try to prosecute the witness. I mean, he's not a defendant at this, he's a witness at this time. And I think maybe we should do that.
Should I ask? Oh, there he is. That's Mr. Jones right here.
Yes, sir, Mr. Jones, come on up so we can determine what you desire to do about being represented by counsel, you've talked to Mr. Shack?
No,
You have
That's
not?
me. That's, yeah.
I spoke with him.
Yes.
Spoke with him briefly.
Yes. And there's an issue about whether you believe you should have a lawyer, which if you desire to have a lawyer, the court will appoint you a lawyer. Is that what you wish?
Yeah, that'd be fine.
All right. Considering, I'm not concerned about whether he's indigent. You seem to think that he might
He
have
said he
been.
couldn't, tried to find one, couldn't get one. That's what you told me, sir.
No, nobody wanted to pick it up, being that it was that close at it.
I need for you to speak loudly so the
Yes.
court reporter can
Oh,
pick up
nobody-
what you're saying.
Nobody wanted to pick it up, being that it was so close to coming to court.
Yes.
Your Honor, I know Mr. Jones was recently represented by the Public Defender's
Right.
Office here in Durham on a matter that just terminated a couple weeks ago.
All right. Is that correct, Mr.
Yes,
Jones?
that's correct.
All right. Do you desire some member of the Public Defender's Office to represent you?
Yes, that'll be fine.
All right.
Judge
Yes. You got an issue.
Lawrence Campbell, Public Defender for Durham County.
All right. He doesn't have to be one of your assistants. Can you arrange to have outside counsel?
Yes,
At least.
someone called my office, identified themselves as Mr. Jones. I indicated to him that he should contact someone in the Capitol Defender's Office and speak with them. I don't know if he did that. I will speak with him now, and I will contact the Capitol Defender's Office and see if they can provide an attorney for him.
All right. Would you like Mr. Campbell to do that, Mr. Jones?
That'll be fine.
All right.
Thank you, Your Honor.
All right. What's next? What's next?
I think next, as we start the hearing, I think the issue for the court, I've prepared an opening statement. I don't know if the court would like an opening statement, a forecast of where we're going or not. I know the court has lived with this case as long as we have.
I live with this case, but I've never seen this issue dealt with before. I don't know that there's a procedure that we can go by other than by the seat of our pants.
Or we won't.
Which the two of you should be very familiar with, flying by the seat of your pants, considering that you tried a whole lot of cases in a whole lot of states. So how do you think it should go, this procedure?
Well, we'd like to give an opening statement. I don't know how the state feels about that, but we think it would be appropriate. And if the court's ready, we are prepared to proceed forward with the DNA here.
I think opening statement is fine.
Okay. Your Honor, and I've hooked this up to the electronics. What I wanted to do at the beginning of the opening statement at the start of this case is to go back to the end of Mr. Howard's trial and give you the statements of two people. One is Mr. Howard, who told the court after he was convicted, I didn't kill them girls, I didn't kill those girls. And he repeated it several times, swearing to God he didn't kill those girls. The second is from Mr. Nifong's closing argument to the jury, because Mr. Nifong has in fact framed the issue rather nicely, both for the DNA hearing and for the motion for appropriate relief hearing. Because what he told the jury was this: ladies and gentlemen, you know, despite the fact this case was never investigated as a sexual assault and it was never suspected to be a sexual assault, Mr. Van wants to make it a sexual assault. And why? Because he knows the defendant never had sex with Nishonda or Doris. So if he makes you believe that the killer was somebody who had sex with, it says him, but he meant them, then obviously it couldn't be the defendant. So taking Mr. Nifong's words and turning them around a little bit, the issue's real simple in both hearings when we talk about favorability. If there was a sexual assault, this man's innocent. State admits it. Mr. Nifong admitted it at trial. And sometimes the criminal law does get easy when we talk about complex issues, but the basic proposition is fairly straightforward. And we've talked about what does that mean in the context of the DNA here, 15A 270C, which talks about favorability. And what it says is if the results are conducted under this section are favorable to the defendant. Now, favorable to the defendant, the state argument on appeal should be interpreted as meaning the test results create a reasonable probability that the verdict would be more favorable to the defendant had the results been available at the first trial. In other words, based on these results and based on the evidence presented at the original trial, would a reasonable juror have a reasonable doubt about Mr. Howard's guilt? So, how does this all fit in? Well, we begin with this crime scene, because favorability has to be determined against what was known and what we know. And what we know, and this is the crime scene diagram that was introduced as State's Exhibit 3 at the trial. What we know is both victims are found on a bed. They are naked. There's a fire going on in the closet, and you can see a fire origin notation. They've both been strangled. Nishonda, the 13-year-old, has died of strangulation. Doris, the mother, has died actually of a beating and blunt trauma causing bleeding in her liver and her pancreas. We also know that there is a laceration halfway up the vaginal canal in Doris that was inflicted just before the time of her death. That's what we know. Now, so we also know that Nishonda has semen in her anus. And this was all known as of 1993. And in 1993, we know DNA testing excluded Darryl Howard as the person who left semen in her anus. And again, that's what we know about Doris. And there was no DNA testing on Doris in 1993, or 94, 95, because there couldn't be. We didn't have that kind of technology yet. You had to have something that you could see to test for DNA. Your Honor, in 2010, in September of 2010, ordered DNA testing because now we had new technology. And in December of 2010, using that new technology, Doris's vaginal swabs identified an unknown male from the sperm fraction. Sperm was identified in Doris, and an unknown male profile was identified in Doris. So that's a new fact that we know in 2010. An unidentified male in vaginal swabs from sperm is identified in Doris. We also know in December 2010 that the sperm that's identified in Doris is different than the person who left the sperm in Nishonda. Two different men. Not the same man, two different men. And you can see one's unknown male 1, one's unknown male 2, because the DNA profiles are different. So now we know we've got two men leaving DNA in these women, two different men, and we know all of it excludes Darryl Howard. And so that excludes Mr. Howard. Then, Your Honor, in March of 2011, because the DNA profile we were able to get from the sperm in Doris had enough markers, it was submitted to the CODIS system. The CODIS system is the FBI database on all felons in the country that keeps the DNA. Your Honor ordered the FBI to do that. And in August 2011, CODIS got what's called a cold hit on an offender named Jermac Jones, actually through the state of Tennessee, where he'd been apparently convicted of aggravated assault in Tennessee. So we also know, based on a report that they provided to us a few weeks ago, that the odds of this being a random hit, of somebody else having the same markers in the same position as Jermac Jones in Doris, Washington, are 1 in 20.7 billion. So we know Jermac Jones is identified, and the odds of it being a random identification are 1 in 20.7 billion. That doesn't stop there. Despite the fact that this report, and we picked this up at the time, it says, per conversation with DA Tracy Klein on August 26, 2011, this codicil will not be pursued by the Durham County District Attorney's Office. Ms. Klein made the judgment, we're done, we're not looking into this, it's over. We don't know why, but that's what we knew in 2011. Except in December 2011, the Durham Police Department went out and got a search warrant for Mr. Jones, which we didn't know about, but which the state has produced to us. Now, Ms. Ellis has just told you all this DNA thing about Jermac Jones is irrelevant and material. Well, you read the search warrant. The search warrant says Jermac Jones's DNA is relevant and material to these violations of the general statute, that is, these murders. They swore an affidavit out. They gave it to a magistrate. The magistrate determined there was probable cause to believe Jermac Jones's DNA was relevant and material and issued an order seizing it. And you can see right there, material and relevant, from the Durham Police Department to the magistrate in a sworn affidavit. So that's another fact we now know, that the Durham Police Department, at least to get a search warrant, said it was material and relevant. And then we know, because we've gotten a copy of the interview, that Mr. Jones was interviewed by the Durham Police Department in 2011. During the course of that interview, he first claims that Doris Washington was his girlfriend. Then he later says he didn't know Doris Washington, and her daughter was his girlfriend. He's asked whether he had sex with her, and he said, I don't know, Doris, but I did have sex with Nishonda. Except remember, his DNA sperm is in Doris and not Nishonda. Nishonda, the sperm in Nishonda is from a different man. And then they leave the room. And after they leave the room, there's no interrogation and no questioning going on. He makes some phone calls. And during the course of one of the phone calls, he's telling whoever he's talking to on the phone what's happening to him. And he says, they set me up in an effing room, and they're wanting to talk to me, and I don't want to rat on anybody. And then he goes on, there ain't nothing to talk about. Ain't nothing they're going to learn without my attorney. Now, if indeed Mr. Jones has nothing to do with the case and knows nothing about the case, then why would he need an attorney so that they could learn something there? And why would he be worried about ratting people out? We view those as, at the beginning, false statements denying that he even knew Doris Washington. And these are incriminating statements, and they're not the result of interrogation. These are voluntary statements he made on the phone when the police were out of the room. So he makes those statements. And that's another fact that the DNA has led us to. And then we interviewed Mr. Jones in December 2012, not knowing the police had interviewed him a year earlier. And he tells our investigator that he was never even in Nishonda's apartment because her mother was so strict. And he's asked, well, how's your DNA in Doris? This is, I don't know, I've never been to the apartment. Maybe Nishonda transferred my DNA. Obviously, it can't be true. None of that can be true as a scientific fact. So he makes more false statements in 2012. And all of that becomes very relevant when we go back to some of what started this case, which was a note from a confidential informant to a police officer, Mr. Project. It was passed along to the head of intelligence, Mr. Hughes. It was then passed along to Captain Sarvis, who then passed it along to Detective Dowdy. And most importantly, the note talks about perps, more than one person. And we know we have DNA in more than one person at this crime scene. And we know none of that DNA is Mr. Howard. So, the evidence against Darryl Howard, at this point in time, Your Honor, there is no physical evidence against him. There's no hair, there's no DNA, there are no fingerprints anywhere. There's no property from the apartment that's found on Mr. Howard. There's no evidence Mr. Howard was even in the apartment. But the DNA evidence that we contend is favorable shows there's male DNA in Nishonda, and it excludes Mr. Howard. We also know the DNA in Nishonda excludes Jermac Jones. Doris has a sexual assault injury. There's male DNA in Doris. The male DNA is Jones with a 1 in 20.7 billion chance. Jones makes false statements. He makes inculpatory statements. And the DNA validates the confidential informant tip that there were perpetrators, multiple people, not just one, which was the state's theory at trial. Remember what Mr. Nifong said. It was a sexual assault. This man's innocent. That's why this DNA evidence is favorable. It would have created a reasonable doubt in the mind of any reasonable person that this man's guilty of anything having to do with these murders.
All right, Giselle.
Thank you, Your Honor. Your Honor, over 20 years ago, 1995, the jury sat right here and they listened while each of the witnesses testified in a trial against Mr. Darryl Howard. And Your Honor, in each of those, they have presented evidence. They presented the fact that there was no DNA. They presented to these individuals, there was not a spot of DNA evidence, there was not a spot of physical evidence tying Mr. Jones or Mr. Howard to the crime. They listened. They looked at the witnesses. They evaluated the credibility of the witnesses. And they came back that even though his DNA was not there, that he was guilty. On top of that, the North Carolina Court of Appeals, in their judgment, and that's COA 95-1156, stated numerous times that the DNA did not match Howard, but there was sufficient evidence for each element of the crime to uphold that. Your Honor, when we look at this case, we have to look at all of the evidence, even in a 269-270 hearing. The rules for 269 state that a defendant may make a motion before the trial court and enter a judgment against the conviction of the defendant for performance of DNA testing if testing complies with FBI requirements, meets NDIS criteria, and all of the following conditions. It is material to the defendant's defense. It is related to the investigation or the prosecution that resulted in the judgment, and meets either of the following conditions. It was either not tested previously, it was tested previously, but the DNA test would provide results that are significantly more accurate and probative of the identity of the perpetrators or the accomplice, or have reasonable identity, or could possibly contradict prior test results. Your Honor, in this case, the test results don't contradict anything. We knew that it was not Mr. Howard's DNA. We knew that there was no physical evidence there because there was a fire set. And Your Honor, the jury got to hear from all the experts who heard about the firefighters coming in and finding Doris and Nishonda lying naked. What did they do? They didn't leave them there. They picked them up and carried them outside. This was an active scene with a lot of people in Few Gardens. The report, the trial transcript, and everything state that the firefighters actually had to fight the crowd off because they were attempting to save their lives. They didn't know that they were dead already. They were sitting there out in this scene that was not clean. They also had the possibility of a fire that could lead to possibly spreading in the other dormitory-like buildings that were in Few Gardens. I'm sure you've never been to Few Gardens because it doesn't exist anymore. Your Honor, the totality of this case rests on just what they are arguing is material. But let's take a look at that. Materiality, they didn't even actually allege it properly in the motion for the DNA testing back in 2011. DNA evidence alone in isolation cannot be looked at to determine automatically that it is material. Just because it's there doesn't mean it's material. Instead, you must be judged with all of the evidence, looking at the DNA and all the evidence produced at trial. And that, you can look at State versus McLean. I believe that's 232 North Carolina App 111. I believe that's exactly at page 118. That's a 2014 case. If we look at case law, State versus Olvander, the defendant was accused of rape and incest and ultimately convicted as he pled guilty. 10 years later, post-conviction, the defendant filed a motion requesting DNA testing. However, the SBI didn't find sperm on the victim, no incriminating DNA on the evidence or on the victim. The plea was, however, based on the victim's injuries, the victim's statements, the victim's identification of the defendant, corroborating statements made by the witnesses. This case is analogous in that convictions were based on the judge's review of the evidence and considering all of the evidence, the victim's injuries, the witness ID, the circumstantial evidence, the corroborating evidence made by the other witnesses, stated that it wasn't favorable. The defendant hangs his hat on the theory that if the state can't prove that he had sex with the victims, that the state can't convict. And this is merely a continuation of his trial strategy. Therefore, the DNA is inconsequential and not material. And even if we look over to favorability, under 15A269, an evidentiary hearing is conducted to determine the favorability of DNA. And as Your Honor stated, the statute does not define the standard that we use for the determination of favorability. However, in State versus Norman, 2002, North Carolina App 239, at approximately 331, that's a 2010 case, we must look at case law for guidance because favorability result is a culmination of looking at all of the facts. In the Norman case, he had 2 counts of kidnapping, 2 counts of sexual offense, and crimes against nature. The DNA testing was granted in that case, and the DNA analysis said that the sperm was a mixture of 2 or more individuals that neither included nor excluded the defendant. So therefore, it has a broad list of probabilities that that sperm came from different races and nationalities. But that was ruled not favorable because the tests did not exclude the defendant as a perpetrator of the crime. Therefore, favorability could be looked at as a result taking into account the underlying crime and a look at whether new DNA results would exclude him as a perpetrator. In our case at bar, DNA doesn't exclude. While it might simply further an argument of the defendant that he has long held and that is presented to the jury, it is not enough to be favorable. It's merely a red herring in this case. Your Honor, if we look at this case against Darryl Howard, if I can have the screen up. Your Honor, there was multiple occasions in this case where Mr. Howard was identified and where all of this information was known. In 1993, DSS was called, and this is actually from a filing that is located downstairs. And Your Honor, first of all, I want to say that, well, this was actually filed because it stated that Nishonda reported that she was running away from home because her mom was beating her. She was also stated that Nishonda was running away from home and her mother was, her drug deals were going bad. This is in our records downstairs. By merely going down here to the court, one could find these records. And the reason why this is important is that the DSS records were actually looked at and evaluated by both Mr. Nifong and Mr. Van and the presiding judge. That's in the transcript. The reason why that's important is Nishonda ran away with her boyfriend. That was known. That was known at the time. Your Honor, then we go to November 27th, 1991 at 1 a.m. That is when the homicide occurred. We look at Suggs. Suggs testified in the trial. He gave an account, stated that he and Drew and Joe went into the apartment. They testified to this. And that is important because it counters what Mr. Howard says. They say that he's got an alibi, they say all of these things, but Mr. Howard was actually on the scene. In fact, he told police officers later that I saw 3 guys going in. That's after he set the fire. Your Honor, also, if you look at November 27th at 7 a.m., Officer Howard, Officer Davis arrested Howard for driving a burgundy vehicle in Kew Gardens. All of these are particular instances of people seeing Mr. Howard at the scene on that day. He actually was arrested at that time, and Bates stamp number 1544 and 1545 shows that Mr. Howard spontaneously stated at that time, this is just several hours after the murder, that Doris had killed Nishonda and then had killed herself. Officers weren't even asking him about that. They were arresting him for trespassing in the area and driving with license revoked. He was then released. 7 o'clock in the morning, he's arrested for trespassing in Kew Gardens. Then, at 11:30, he's arrested again in Kew Gardens. This time for being at Ms. Bass's house, where he was found with several bags of crack, and he was also processed at that point and spoke with investigators again. That is where he actually mentions, oh, I saw Doris, she was talking with the New York boys. He is the one who puts the New York boys there. He is the one who always perpetuates this story right from the beginning, Mr. Howard. Then Ms. Rhonda Davis gives a statement. Then Ronika Jackson on November 31st gives a statement that Darryl Howard threatened to kill Doris and Stephen Cox. Present were Rosa McPherson, Dwight Moody, Valeria, and Otis saw Darryl come out of the house with a VCR. It's important to understand this because this is right near the murder, at the time. These individuals came in and they testified to this. Then we come to the note, and they argue that this is relevant, that this was never turned over, that there's a whole bunch of shenanigans going on with this. However, this note, Your Honor, several people in this room have worked on innocence projects and have dedicated some of their time to looking at innocence cases and know that when you bring forward a claim of innocence, it's kind of your duty to, I don't know, investigate what it is that you're alleging. Your Honor, Mr. Pradka, the alleged officer who wrote this note, was readily available. They did not go out and look for him. The state did. The state went out. We sent an investigator. We spoke with him. He said some random guy gave him this information that he could not tell who it was because he didn't know who it was. And furthermore, he provided some information that was turned over to the Innocence Project. However, like I stated, we went into the phone book, found him, went out and talked to him. They did not. They, for years and years and years, sat on this note, never went and spoke with Mr. Pradka, and never attempted to find out this information. Because it's not relevant, because they can't do anything with it. And that is case law. Case law shows that if there is a piece of evidence that shows that it's a possible witness that they can't prove, that they can come in, they don't know how this person has this evidence or anything like that, of that nature, then they can't use it. All it could possibly be used is to impeach at the time of the trial, and that is not new evidence. Furthermore, we've got Kevin Best, who came in and testified to pretty much the same thing, that he saw Darryl Howard leaving near the rear of Doris's apartment, that he was driving a burgundy vehicle. We've got Dwight Moody Moss, who his testimony has been the thing of prior Court of Appeals review and found to be okay. Your Honor, then we have a tip. A tip that says that Darryl Howard and his brother went into the victim's house, tied Doris up with a wooden stick behind her back, and beat her. Your Honor, the victims died, victim Doris Washington died of a severe beating. In fact, the trial transcript shows that they asked if this could be the lacerated liver of the victim could have been from someone kicking her repeatedly and with a knee. The note also noted something about the VCR, which is important because this is fairly close again to the crime. A tip received from a confidential informant. Your Honor, the officers actually went out. We have went through this case. We have gone through each one of the files, followed up on this, and if you look at all of the case, the officers did a fantastic job. They were able to get one of the confidential informants and track her down, and she actually came in and testified against Darryl Howard. And that individual stated that Darryl Howard bragged about killing him and said, watch if somebody else messes up my packages. Then the Crime Stoppers tip came in a while later, March 16th, 1992. And officers, even though they had all this information, still investigated the case because they wanted more. Then, and this is in their discovery that they had, Eric Shaw.
Your Honor, this particular piece of evidence, some of the other evidence, wasn't introduced at trial. We don't have a problem with her talking about what was introduced at trial, but Your Honor decided this in the Peterson case, and the Court of Appeals affirmed it, but they are stuck with the trial record as far as his guilt. They can't continue to refer to things they didn't introduce at trial. And so we would object to that.
Your Honor, they are stating that there was linkage between that, so I'm simply stating that they are referring to items that show that Mr. Howard didn't do it. And I am clearly showing that there's information that he did. This is information that has been given to him. This is part of the record that they have. And this is showing information that they failed to follow up on as well.
Overruled. Go ahead.
Thank you, Your Honor. Your Honor, then Darryl Howard, or correction, let's go back. Eric Shaw messed up the package and also owed the New York boys. In this interview that was turned over to the defense, they stated that Darryl was ordered to kill Doris in order to clean his slate with the New York boys. That was information that was known to the defense at the time and to the Innocence Inquiry or Innocence Project. Your Honor, then Darryl Howard was shot by somebody who said it was a New York boy. and that was in June 1992. Howard also told officers that a guy named Bug sold him the VCR. Your Honor, he puts himself not only there at the scene, but now he's trying to create reasons why he has some of the evidence from that scene. Your Honor, also November 10th, 1992, Angela Sutherland testifies. She talks to officers. She tells them that she knows about the Few Gardens murders. She gives a statement that she, Darryl, and Kenny went to Doris's house to get drugs. Your Honor, all of the evidence up till then show that Darryl, his brother, and another woman went in, that the woman came out. So all of this information was showing that Darryl Howard was present, and then this is when they came forward and they had the lady who was in the house. And her testimony, as the Court of Appeals stated, as many of the different investigatory bodies that looked at this case previously stated, was corroborative of all of the evidence presented against Mr. Howard at trial. Warrant was then issued, and this is where it gets interesting, because the person who indicted Darryl Howard was ADA Mary Winstead. His first trial attorney was Mr. Brian Ouse. Mr. Brian Ouse filed a motion for discovery in November 25th, 1992. December 7th, 1992, Mr. Howard wrote a handwritten motion for discovery, and in that he's basically stating that he wants to get the DNA because he knows the DNA doesn't do anything against him. In February 2nd, 1993, Bob Brown motions the court for DNA hearing. The state doesn't go forward with the DNA hearing. In fact, the state will introduce at this hearing several newspaper articles that chronicle the bond hearing and the requests for DNA testing that show that Mary Winstead stood up and stated this isn't a sexual assault crime. We're investigating this as a murder, that this DNA is not material. Over and over again, this has been pre-litigated. Also, Your Honor, one of the most disturbing aspects of this was that in the defense MAR, they argued that this note was corroborative of their fact that the defense, or that the state had changed their motive somehow, and that they were actually investigating this as a sexual assault crime. However, once again, this goes to show that they did not do their homework. They didn't corroborate this. They didn't go back. And had they just merely done their homework, gone to the library, and looked at the news articles for the bond hearing, they would have seen that this is Mary Winstead copying down what the defense argued. And the most disturbing thing is that they knew that it was Mary Winstead's notes because they had talked to Mary Winstead, and they didn't put that in their MAR, that they knew that this was Mary Winstead's handwriting, that they knew that this was Mary Winstead. Your Honor, the screening report, which the note was found in, bound, is given over to the prosecution on November 14th, 1993. We can see that because that's at bait stamp number 1156, and on the cover sheet it shows the date and time received. Now, Your Honor, this information was found in a bound screening report. That screening report is the report that basically the police officers turn over as their initial part of the investigation. And that is where this note was actually found that they're claiming that they're kind of hanging their hat on that wasn't turned over. But it was bound in this book. It wasn't hidden. It wasn't saying, there wasn't no note on it that said don't turn over to anybody. Furthermore, Your Honor, there are several other notes that were turned over to the defense or to the inquiry in this matter. different people in this case. Mary Winstead was still involved in May 9th, 1993, when she wrote a note for a discovery letter to public defender Bob Brown. Also, on June 1st, 1993, the SBI reports came back. The SBI reports stated that Mr. Howard was excluded. Everybody knew this. Everybody knew this. Furthermore, in January 10th, 1994, there was a note that stated Bob Brown and ADA Mary Winstead were still part of this case. January 10th, 1994. Then Mr. Howard files a pro se motion for a speedy trial and refers to the fact that the DNA did not match him, and he also states that this case is being handled by ADA Winstead. This is January 26, 1994. And in fact, some of the language in this handwritten motion is basically the language that they use in theirs. Furthermore, on November 9th, 1994, Mr. Bob Brown withdraws as counsel, and Mr. Woody Van is appointed. After that, the trial's in March 1995. Court of Appeals upholds the convictions June 1996. So when you look at 15A 269, 15A 270, Your Honor, you have to look at materiality and favorability in light of all of the evidence that was presented and that the jurors actually got to look at. They got to evaluate the defendant's credibility as he took the stand. One of the most important things about when he took the stand, Your Honor, is that he told them, Mike Nifong asked him on the stand, he said, did you sell crack from Miss Bass's house? He says, no, that's something that I would not do. Your Honor, if we go back, he was arrested several hours after the homicide at Mrs. Bass's house. Doing what? That was an arrest for cocaine that he was found after he had already been released for trespassing in Kew Gardens. Your Honor, in this, I understand that there's going to be a lot of evidence. We're going to come back and argue that it is not relevant, it is not material, and it is not favorable.
All right, counsel.
Your Honor, I mentioned the Peterson case earlier. I think it's going to be an issue, so I've made copies of that decision from the Court of Appeals. And with the court's permission, I'll provide the court a copy. And the operative language appears on this page. As Your Honor may recall, at Peterson hearing before the court, substantial evidence was presented about Mr. Dwayne Deaver and his qualifications. In response, the state sought to introduce evidence they had not introduced at trial, but they claimed was further evidence of Mr. Peterson's guilt on the theory that, therefore, whatever Mr. Deaver said was not material. Your Honor excluded that evidence. Your Honor permitted the state to cross-examine witnesses about their qualifications and opinions and what they were saying. But you barred the state from introducing evidence that wasn't introduced at the trial. You issued an order in Mr. Peterson's favor. It went up to the Court of Appeals. The Court of Appeals affirmed the court, and it specifically affirmed your ruling that the state's not entitled to introduce collateral, what they term collateral evidence, that is evidence that was not introduced at trial, in an attempt to show there was other evidence of guilt, and therefore the newly discovered evidence in that case was not material. As I say, it appears that that's going to be an issue as we go forward, so I just wanted to bring that to the court's attention.
Well, Ms. Ellis, is that going to be an issue? Or
No,
not?
Your Honor, I believe that the evidence given to the court, to the jury, was enough to convict.
All right. She says it's not going to be an issue.
Good. And then, Your Honor, at this point, I would like to tender into evidence what we marked as Defendant's Exhibit 1, which is the trial transcript. The trial transcript, technically, is already part of the record, but I thought we needed to have it specifically in the record for this. And if you could hand them a copy.
All right. The motion is allowed.
On behalf of Darryl Howard, the defense calls as its first witness Megan Clement.
Ma'am, can you place your left hand on the Bible and raise your right? Do you solemnly swear that the testimony that you should give the court in your case now being heard is the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do.
Please state your name for the record.
My name is Megan Clement. Excuse me.
Ms. Clement, what is your occupation and where are you currently employed?
I am the Director of Operations at Bodie Selmark Forensics in Lorton, Virginia.
Ms. Clement, what I would like to do is break your direct examination into 3 categories, if that's okay with you. If it's okay with you, the first thing I'd like to... If it's okay with you, can you hear me better now? The first thing I'd like to cover with you are your credentials and your background. And the second thing I'd like to discuss with you is a summary of your conclusions in this case. And the final thing I'd like to cover with you is a more detailed description of the testing conducted by your lab and the basis of your conclusions. Is that okay?
Certainly.
So let's start with your credentials. Please describe your academic background.
I have a bachelor's degree in biology from Westfield State College in Massachusetts and a master's of science in forensic sciences from the University of New Haven in Connecticut. I've also obtained graduate level credits from courses that I took at the University of New Mexico in Albuquerque, as well as the University of Virginia. Those courses were actually taken at the FBI Academy in Quantico, Virginia, and they had an agreement with the University of Virginia to provide credits for courses taken there.
Describe for the court your previous employment. Let's start with your first job after graduating from your master's, if that's okay.
My first job, I started in March of 1985 at the Albuquerque City Police Department Crime Laboratory. At that point in time, DNA analysis was not being used in forensics, so I was hired as what was referred to as a serologist. I was hired as a criminalist, and in the serology section, we studied blood and body fluids. We examined evidence to identify potential stains from crime scene evidence. We would analyze those body fluids for ABO blood typing and enzyme types to attempt to partially discriminate and make comparisons to known reference samples. At the time I was in Albuquerque, I was also qualified as a crime scene analyst, so I was on call to go out to homicide scenes to process and collect evidence. I also did blood alcohol analysis, as well as provided some teaching to other crime scene analysts and detectives on how to properly collect evidence so that there was no cross-contamination, how to package that evidence, ensuring that it's dried so that the enzymes wouldn't degrade. It was also during my tenure in Albuquerque that I started my DNA training. DNA really came onto the scene in the late 80s, I attended a one-month course at the FBI Academy in November through December of 1989. And after that course, I was invited back to the FBI as a visiting scientist. So in 1990, I was a visiting scientist at the FBI Academy for approximately 3 months, performing various research projects there. When I came back to Albuquerque, I started performing validation studies and setting up their RFLP DNA laboratory. So I was performing the validation studies, creating databases, and I continued to do that until I left Albuquerque in March of 1991.
And where did you go in March of 1991?
In March of 1991, I moved to Texas. I was employed at the Tarrant County Medical Examiner's Office in Fort Worth, Texas. And they currently had DNA testing online, so I started immediately analyzing both serology and DNA testing on evidence. I also continued to do crime scene processing at the Fort Worth Medical Examiner's Office, and continued doing that until November of 1994.
Did you perform any DNA testing at the medical examiner's office?
I did, yes. We performed RFLP testing.
And then where did you go in 1994?
In 1994, I moved to North Carolina, where I took a job at what was originally Roche Biomedical Laboratories in Research Triangle Park. In 1996, it became LabCorp, or Laboratory Corporation of America Holdings Incorporated, which trademarked the name LabCorp. And I stayed employed at LabCorp. I was hired as an assistant director, eventually was promoted to associate director and then technical director, and I remained there until July of 2012.
And what were your responsibilities at LabCorp? What type of, if any, DNA testing did you conduct?
Yes, we did all DNA testing as well as some serology. I was responsible for performing the actual testing originally. As the years went on, my position changed to the point where we had technologists who handled the majority of the hands-on work, but all of the raw data would be given to myself and other co-directors. We would interpret all of the data, draw conclusions, write the reports, and testify as to those results. My position basically was to direct the operations of the laboratory. We performed both RFLP very early on, as well as the more recent technology, PCR analysis.
And in July 2012, where did you go?
In July of 2012, well, actually, in the end of June of 2012, they closed down the North Carolina laboratory. LabCorp had purchased a laboratory in Texas, right outside of Dallas, and they made the decision to close the smaller lab, which was located here in North Carolina. So I relocated to just outside of Dallas, Texas, and began working for the combined laboratories that were branded Cellmark Forensics.
And what were your responsibilities at Cellmark Forensics?
At Cellmark Forensics, I was the senior director, and I was responsible for the laboratory operations. I also continued interpreting data, writing reports, technically reviewing various cases, testimony, and basically day-to-day operations, which included both quality control as well as testing methodologies.
And when did you leave Cellmark?
I left Cellmark. It's a bit of a fuzzy period. LabCorp purchased a laboratory in Lorton, Virginia in December, or actually the end of November of 2014. In March of 2015, they made the decision to close the Dallas lab and to consolidate all of the testing functions into the Lorton, Virginia laboratory. So I started doing some work at the Lorton, Virginia laboratory around August of 2015, but I was also still responsible for assisting in closing down the Dallas laboratory. So I had dual responsibilities. I was flying back and forth between Dallas and Lorton, Virginia. So I technically moved to Lorton, Virginia in August of 2015, but didn't actually end my total employment in Texas until December of 2015. So I've been in Lorton since then.
And what are your responsibilities at Bodie Cellmark?
At Bodie Cellmark, which is the newly branded name of the Lorton facility, I am the Director of Operations, and I am responsible for all of the laboratory operations and quality control.
Ms. Clement, how long have you been a forensic DNA analyst?
I have been a forensic DNA analyst since, I would say 1990, when I started validation studies in the Albuquerque laboratory.
So in those 25, 26 years, how many DNA cases have you worked on?
Over 10,000.
Can you give a number or an approximate percentage of how many of those over 10,000 cases involve testing items from a sexual assault kit?
The majority of the work in the crime laboratories did involve sexual assault kits. I would say probably at least 70 to 75% included either a sexual assault kit or an item from the sexual assault kit.
So that's about 7,000 or 7,500.
That's correct, yes.
Now, in the 10,000 plus cases you've worked on as a DNA analyst, were you performing testing for the prosecution or the defense?
Actually, both, although the majority was for the prosecution, probably 80 to 85% was for prosecution.
And by the way, you testified that you worked at LabCorp from 1994 to 2012?
That's correct, yes.
Did you ever, during those 17, 18 years at LabCorp, perform DNA testing for the state of North Carolina?
Yes.
And do you belong to any professional organizations?
I do, yes. I belong to the American Academy of Forensic Sciences and the Northeastern Association of Forensic Scientists.
During your career, have you ever been qualified by courts as an expert in the field of forensic DNA analysis and permitted to provide expert testimony in this area?
Yes, I have.
And approximately how many cases have you been called to provide such testimony in this field?
Approximately 362 times.
In those over 350 times you testified, were you testifying for the prosecution or the defense or both?
Both. Again, the majority of them were for the prosecution, but I have testified for both prosecution and defense.
And when you say majority, could you quantify that?
I would say probably 80, at least 80% of the time was for prosecution.
Okay. Your Honor, may I approach?
Yes.
I'm marking as defendant's exhibit 2 a document. Can you identify this document?
Yes, I can.
And what is it?
It is a copy of my curriculum vitae.
And does it accurately list your background, education, and work experience as a DNA analyst?
Yes, it does.
Your Honor, at this time, I'd like to offer Ms. Clement as an expert in forensic DNA analysis.
Your Honor, I have no objection to that. I'm familiar with Ms. Clement.
All right, motion is allowed.
And I'd move to admit her CV as defendant's exhibit 2.
It's allowed.
Ms. Clement, I'd like to turn your attention to this case. Did LabCorp perform DNA analysis in the Darryl Howard case?
Yes, we did.
Now, before we get into your conclusions and the details of the testing, I'd like you to assume a series of facts. I'd like you to assume that at Mr. Darryl...
Your Honor, at this juncture, I would oppose to the assumption of facts.
Your Honor, the facts that I'm asking her to assume are, as you will see, undisputed facts in the trial record. They're facts that either were testified to by the state's own witnesses or in reports that were submitted by the state's witnesses, and I'm simply asking whether the witness is aware of the facts that relate directly to the testing that her lab conducted in this case.
Your Honor, then I would ask that she ask in a correct manner if she is familiar with these facts and if they are facts that are known to her.
I plan to do so.
Your Honor, she is asking that they're assumed to these facts, and that is not what she asked.
Well, actually, I think that's just the way some people ask expert witnesses questions, so overruled.
So let me start over. I'd like you to assume a series of facts. I'd like you to assume that at Mr. Howard's criminal trial in 1995, over 20 years ago, evidence was introduced that just before Thanksgiving in November 1991, 2 women were found dead in their home, Doris Washington and her 13-year-old daughter, Nishonda Washington. Their bodies were lying face down on one bed, and both were found completely naked. Is that consistent with your understanding of this case?
Yes.
I'd like you to assume further that the mother, Doris Washington...
At this point, I understand how she's doing this, but this is not proper direct.
I think it's proper direct of an expert witness.
Yes, Your Honor.
Over.
I'd like you to assume further that the mother, Doris Washington, had blood-tinged fluid in her vagina, as well as a half-inch laceration with nearly smooth edges in her vaginal vault, located about 1.5 inches from her cervix. Is that consistent with your understanding of this case?
Yes.
Finally, I'd like you to assume that her 13-year-old daughter, Nishonda, was also found naked on the same bed, and that the medical examiner observed sperm at autopsy in her anal cavity and observed cream-colored fluid in her vagina, and that the state crime lab subsequently identified sperm in both the 13-year-old's anal and vaginal smears. Are you aware of those facts in this case?
Yes, I am.
Your Honor, may I approach again?
Yes.
I'm showing this listed as Defendant's Exhibit 3. Do you recognize this document, Ms. Clore?
Yes, I do.
And have you seen it before?
I have, yes.
Can you identify it?
Yes, I can. This is a laboratory report that was issued by the State Bureau of Investigation and outlines items that were submitted to their laboratory as well as testing that was performed. And the report is dated March 26th of 1993.
Have you seen reports like this before from the State Bureau of Investigation?
Yes, I have.
And are these the types of reports that experts in your field reasonably rely on?
Yes, they are.
Now, directing your attention to page 1, what are items 1B and 1D on this page?
Item 1B are 2 vaginal smears, and item 1D are 2 rectal smears that were obtained from the sexual assault evidence collection kit of Nishonda Washington.
And directing your attention to page 2, what does it say about items 1B and 1D?
Items 1B and 1D says that microscopic examination of the vaginal smears and the rectal smears revealed the presence of spermatozoa.
In which victim?
In the Nishonda.
Now, you mentioned that you have experience conducting RFLP testing. You did that at both the medical examiner's office and I think also at LabCorp?
Yes, actually, yes. I performed RFLP testing in Albuquerque. However, we never had implemented it before I left there, so I did on casework at the medical examiner's office in Texas as well as at LabCorp.
And what is RFLP testing?
RFLP stands for Restriction Fragment Length Polymorphism, and it was the original type of DNA testing that was used in forensic laboratories. It required a very large quantity of DNA, and it had to be a very high quality of DNA. It could not be degraded.
Now, in the early 1990s, when you were conducting this earlier generation DNA testing, could a lab at this time compare sperm found in a victim's rape kit to a suspect's DNA sample and determine whether that suspect could or could not have contributed that sperm?
Yes.
And could labs at that time come up with some sort of statistical measurement to determine how rare or common that particular RFLP DNA profile from the sperm was?
Yes.
And was RFLP a fairly discriminating test?
Yes, it was.
So in the early 90s, when RFLP was available, let's assume police identified a suspect. in a homicide case where one of the murder victims is a 13-year-old girl who was found naked. And during her autopsy, the medical examiner identified sperm in her anal cavity. Based on your experience and your training, would an investigator collect that suspect's DNA sample and send it to the crime lab to investigate whether he was the source of the sperm in that teenage victim?
Yes, absolutely.
And is that the type of investigation, in your experience, something that law enforcement would routinely do in a case where sperm is identified in a murder victim?
Yes.
And immediately do?
Generally, as soon as they got the reference sample, yes.
And if law enforcement had multiple suspects, would they run the DNA from the sperm found in the victim against other suspect DNA samples?
Yes, they would.
And in fact, if the cops thought the semen came from the 13-year-old's consenting partner, they could identify possible donors and test each and every one of them, couldn't they?
Yes, they could.
And that's assuming a 13-year-old can actually consent to having sex, right?
Yes.
So, I'd like to, hold on one second. Are we up to 4? 5? Your Honor, may I approach? Showing the witness what has been marked as Defendant's Exhibit 4. Ms. Clement, do you recognize this document?
Yes, I do.
And have you seen it before?
I have, yes.
And what is it?
This is a laboratory report from the State Bureau of Investigation dated June 1st of 1993, which outlines the results of RFLP testing that was performed at their laboratory.
And what were those results?
The results were that the banding pattern obtained from the vaginal swabs and the rectal swabs did not match the banding pattern that was obtained from the blood stain of Darryl Howard.
Now, when did LabCorp begin DNA testing in the Darryl Howard case?
In September of 2010.
And was that testing conducted pursuant to court order?
Yes, it was.
Your Honor, may I approach?
Yes.
Handing you what has been marked as Defendant's Exhibit 5. Do you recognize this document?
Yes, I do.
And can you tell us what it is?
Yes, it is a certificate of analysis, which was a report which outlines evidence that was submitted to LabCorp, as well as the results that were obtained and the conclusions that were drawn.
Your Honor, I'm sorry, I'm going to do a little hard labor and move a couple things around.
Was that this Defendant's Exhibit 5 is a photocopy of the Certificate of Analysis, which is the report which outlines the evidence that was received at LabCorp, the testing that was performed, and the results of that testing, as well as conclusions that were drawn.
And who prepared this report?
I did.
And was this report prepared in the ordinary course of business at LabCorp?
Yes, it was.
And is that your signature on the third page, on this page of the report?
Yes, it is.
Now, let's break down this report a little bit. So I put this a little out of order. This is the first page. What information is identified on the first page of this report?
The first page lists all of the evidence that was received, the date it was received. It lists the LabCorp case number that this evidence was assigned. It lists who the submitting agency was, as well as the victims and the subjects in the case.
And the second page of the report is some sort of chart.
That's correct. The second page of the report is the actual results that were obtained for each of the items that were tested.
And your conclusions start on the second page and continue to the third, is that correct?
That is correct, yes.
So, Ms. Clement, does this report accurately state your conclusions from testing of the sexual assault kits from Doris Washington and Nishonda Washington?
It does, yes.
And were your conclusions, what were your conclusions based on the scientific testing of the vaginal smears and the rectal smears of Nishonda Washington and the vaginal swabs of Doris Washington?
The conclusions were that we did obtain, first I'm going to talk about the smears of Nishonda. The vaginal smears and the rectal smears did reveal a male profile, and Mr. Howard was excluded as a source of that male profile. And then for the vaginal swabs of Doris, we obtained a separate male profile, and Mr. Howard was also excluded from that male profile.
So neither male 1 nor male 2 was Darryl Howard?
That's correct. He was excluded from both of those.
And do you agree today with the conclusions you provided in this report?
I do, yes.
And after this report was prepared, what did you do with it?
I submitted the original report back to the Innocence Project and also to the court, or to the district attorney's office.
So let's go through, Your Honor, I'm going to move to admit, I forgot to move to admit the prior to defendants exhibit 3 and 4, so I'd like to admit those at this time. I'm going to move to admit this one a little bit later once we go through the details of the testing.
No objection, Your Honor.
All right, motion is allowed.
So let's go through the details of the testing in this case. When did LabCorp receive the evidence in this case?
We received the evidence on September 23rd of 2010.
And how did you receive the evidence?
I actually went to the State Bureau of Investigation and picked up the evidence personally.
You picked it up in person.
I did, yes.
I'd like to show the witness what's been marked as defendant's exhibit 6. Your Honor, may I approach? Do you recognize this document, Ms. Clement?
Yes, I do.
And what is it?
This is the North Carolina State Bureau of Investigation request for examination. On the bottom portion of the page, there is a chain of custody section, and this is where I actually signed that I received the evidence.
Are the items listed in this document the same items that you picked up in person from the State Bureau of Investigation, North Carolina, on September 23rd, 2010 for DNA analysis?
Yes.
I'd like to show the witness what's been marked as Defendant's Exhibit 7. Ms. Clement, do you recognize this document?
Yes, I do.
And this is a copy of a document we received from the state. Have you seen documents like this before from the SBI?
Yes, I have.
And what does this document appear to be?
This document is a more detailed chain of custody of the items from the time that they were received by the SBI until the time of their completion.
So it traces the chain of custody from, is it the police department to the SBI to LabCorp?
Yes, that's correct.
And is this the type of chain of custody documentation that experts in your field reasonably rely on?
Yes.
Your Honor, I'd move to admit Defendant's Exhibit 6 and 7.
So allowed.
6 and 7. Okay. 5 I was going to do later. It was 5 and 6? Okay. Now, what, if any, chain of custody procedures must LabCorp follow when receiving and testing evidence for DNA?
LabCorp does follow chain of custody documentation from the time that it's received. We track who it was received from, how it was received, where it's placed in the laboratory. We had lockers in the laboratory in various rack areas where evidence was stored. There was limited access. Only people in the forensic laboratory had access to those areas. When somebody touched the physical evidence, that was documented. If it was transferred to and from various lockers, that was also documented. And then the ultimate disposition of when it was returned.
And what's the purpose of those procedures?
To ensure the integrity of the evidence.
And is that just generally accepted practice in your field when receiving
Yes,
items?
absolutely.
And were those procedures followed in this case?
Yes, they were.
Does LabCorp have any policy or practice to prepare chain of custody documentation on your side when evidence is received?
Yes, LabCorp had 2 different types of forms to document chain of custody evidence. Mm-hmm.
Okay. Showing the witness what's been marked as Defendant's Exhibit 8. Ms. Clement, do you recognize this?
Yes, I do.
And can you identify it?
Yes, these are the chain of custody documents that were maintained by LabCorp.
And when was this chain of custody prepared?
It was prepared at the time that the evidence was brought into the laboratory.
And what are these numbers in the margin next to each item?
The numbers in the margin next to each item are the unique identifying number that was given to each item of evidence by LabCorp. So they're internal LabCorp item numbers.
And was this chain of custody document prepared in the ordinary course of business at LabCorp?
Yes, it was.
I'd move to admit Defendant's 8.
So allowed.
Ms. Clement, after the evidence is received by LabCorp, what is the first step of analysis?
The first step of analysis is an actual inventory of the items that are received. The inventory documents whether something was sealed, what type of container it was in, an appearance of the item of evidence, and how much of the sample was taken for DNA analysis.
I'd like to show the witness what's been marked as Defendant's Exhibit 9. Can you identify this document?
Yes, this is a photocopy of the inventory that was performed on the evidence that was received in this case at LabCorp.
And when was this inventory prepared?
The inventory was prepared on October 12th of 2010.
And is that when the items were taken out of the box for analysis?
Yes.
And what's the purpose of preparing this inventory?
So there's documentation of whether the item was sealed or not sealed, what was actually submitted, how much of a sample was present, and what was taken forward.
And was this inventory prepared in the ordinary course of business at LabCorp?
Yes, it was.
And was this a complete inventory of all of the evidence received from SBI in the case on September 23rd, 2010?
Yes.
I move to admit defendants 9.
It's allowed.
So, Ms. Clement, let's start with the analysis of the sexual assault kit collected from Doris Washington. That's the mother, okay?
Yes.
Directing your attention to page 3 of the inventory that you have in your hand. That's Defendant's Exhibit 9. What is the first item on this inventory?
The first item on the inventory was an envelope that was labeled as vaginal swabs and smears.
Collected from whom?
That was collected, I'm sorry, from Doris Washington.
And what is the LabCorp item associated with the vaginal swabs of Doris Washington?
The item number was 62 for the vaginal swabs and smears.
And so if you're looking with me on page 3, next to 62, it says VAG SP/NSP. What does SP/NSP mean?
What this indicated was that the VAG stands for vaginal swabs, and the SP/NSP indicates that this sample was going to be taken forward for what is referred to as a differential extraction. The SP stands for sperm fraction, and the NSP stands for non-sperm fraction.
Describe for the court what a differential extraction is.
Certainly. A differential extraction is an attempt to separate DNA from sperm cells versus DNA from other types of cell sources, such as white blood cells or what are referred to as epithelial cells. And so it's just simply a chemical process to attempt to differentiate DNA from those two different sources.
And what is the purpose in a sexual assault case or a homicide case that involves a sexual assault of conducting a differential extraction?
To attempt to get a clean sperm fraction so that you can make a direct comparison of the male DNA from sperm to a suspect in the case.
Your Honor, may I approach?
Yes.
I'm showing the witness a copy of a book titled Forensic DNA Typing.
Yes.
Do you recognize the author of this book? Do you recognize this book? Have you seen this before?
Yes, I own a copy of that book. The author is John Butler.
And are you familiar with Mr. Butler?
I am, yes.
And who is he?
Actually, it's Dr. Butler. He works at the National Institute of Science and Technology, and he has been instrumental in developing and researching DNA analysis methods for years.
And are Dr. Butler's textbooks used and accepted as reliable authority in the field of DNA testing and in the forensic DNA community?
Absolutely, yes.
I'd like to mark as defendants 10 a diagram. May I approach? Ms. Clement, I'm showing you a diagram on page 46 of this book that you just looked at. Does this diagram help you illustrate your testimony to this court about what a differential extraction is?
Yes, it does.
And looking at this diagram, Now, using this diagram to illustrate, how does a differential extraction work?
Okay. A differential extraction, originally you would take a small portion or a portion of the sample that you want to test. In this case, for item 62, it was the vaginal swab. So we took a portion of the vaginal swab and we placed it into a what we call a microcentrifuge tube. The morphology of a sperm head and the morphology of an epithelial cell or a non-sperm cell is different. The membrane around a sperm head is extremely hardy and tenacious, and it's a much stronger bond. Whereas the membrane around the nucleus of an epithelial cell or a white blood cell is not as strong. So we take the sample and we put it into a centrifuge tube and we add some chemicals which act as a mild detergent. The mild detergents can break open the nucleus of the non-sperm cell sources, which will release the DNA into the liquid in that tube. Once the DNA is released, it's virtually weightless. So it floats around in that liquid buffer. And we spin down the sample, and because the sperm cells are still intact and have not been affected, they're heavier and they will end up at the bottom of the tube. We can then take the liquid portion and remove it and put it into a second tube, and that becomes our non-sperm fraction or our female fraction, referred to, and it's also referred to as an epithelial cell fraction. So it can have one of three names. We're left with the sperm heads at the bottom of the tube, and we can then add harsher chemicals that will break open the sperm heads to release the DNA from the sperm. And so we end up with a male fraction from that, which refers to the sperm fraction, and a female fraction, which is listed as a non-sperm fraction in our report. So you actually end up with two separate subsamples from your original parent sample.
And so in layman's terms, you're isolating the sperm cells from what you call the epithelial cells.
Well, we're isolating the DNA from sperm cells and the DNA from non-sperm cells.
Okay. I'd like to show the witness what's been marked as Defendant's Exhibit 11. Do you recognize this document?
Yes, I do.
Can you identify it?
Defendant's Exhibit 11 are what are considered bench notes, or notes that are taken and forms that are filled out during the analysis. These are bench notes from the North Carolina State Bureau of Investigation on the analysis that took place on the sexual assault kits of Doris and Nishonda, as well as the reference sample of Darryl Howard.
And is this bench note, or is this the type of data that experts in your field reasonably rely on?
Yes.
Now, directing your attention, I'm going to use the stamp numbers on top. So directing your attention to number 742, Bates stamped at the top.
Yes.
What is the last item on this page?
The last item on this page are 2 vaginal smear slides.
And whose vaginal smear slides are these?
Well, I should say there are 2 vaginal smear slides and 2 vaginal swabs, and these are from Doris Washington.
And what does it say about Doris Washington's vaginal swabs?
It says that the swabs were dried and they were bloody.
Now, in your career as a DNA analyst, have you obtained full male DNA profiles on a murder victim's or rape victim's vaginal swabs where a prior lab was unable to visualize sperm on those swabs?
Oh, sure, yes.
And why would that result occur?
There are a couple of different reasons why that result might occur. One is that there is very few sperm present when a slide is made, or when an item is examined, oftentimes you'll end up with a approximately, let's say, 150 microliters of liquid in a tube, and you might take 5 of that out to spot a slide to look for sperm. So you're only taking a very small portion. If there's very few sperm in the sample to begin with, the portion that you took just simply may not contain sperm. Another potential reason for not seeing sperm is if there is a lot of cellular material, epithelial cells, white blood cells, red blood cells. The sperm are smaller than those types of cells, and if they're underneath other cells on top of it, you may not be able to visualize those microscopically.
So you just mentioned cellular material might make it difficult to visualize sperm cells?
That's correct.
And based on SBI's bench notes on page 7, Bates number 742, what types of cells were seen on Doris Washington's vaginal swabs?
They do note that there were moderate epithelial cells observed.
Anything else? Any other types of cells?
That is the only type of cell, other than the fact that it was bloody. One would assume that they also saw blood cells.
Can blood cells or a bloody vaginal swab make it difficult, in your experience, to visualize sperm?
Certainly, anytime you have additional cells that could potentially cover the sperm, it could make it difficult to visualize it microscopically.
And can the differential extraction process be helpful in testing a victim's bloody vaginal swabs?
Absolutely, yes.
Now, in case I didn't explicitly ask, was a differential extraction performed on the vaginal swabs of Doris Washington labeled LabCorp item 62?
Yes, it was.
Now, after performing differential extraction on Doris Washington's vaginal swabs and obtaining a sperm fraction and a non-sperm fraction, what testing or analysis was conducted?
After the differential extraction, LabCorp, we performed a PCR DNA test.
And what is PCR?
PCR stands for polymerase chain reaction. It is the more modern type of DNA testing that's currently performed in almost every laboratory in the country today. You can get results on smaller quantities of DNA and also on DNA which has been degraded over time.
And why is that important for forensic purposes?
Originally, with the RFLP methodology, as I stated earlier, you had to have a very large quantity of DNA, and it had to be very high quality. It couldn't be degraded. So with PCR, it would allow us to get DNA results from much smaller quantities and also degraded. So for cases that have aged, we were able to get results that you couldn't get results for in previous years using RFLP.
And what are there standards for PCR testing?
Yes, there are standards, absolutely.
And what are those standards?
The standards for PCR testing, there are, gobs of standards. We have standards from the FBI, which are published as the quality assurance standards for DNA testing laboratories that require various control samples that are used, requires protocols be set by the laboratory, requires that validation studies be performed before you ever start using them on work. We have accreditation standards. There are a plethora of standards that are required.
And did LabCorp follow those standards?
Yes, we did.
And were those standards followed in this case?
Yes, they were.
Now, the PCR testing that you conducted, what was that called?
It was a PCR, it was a STR testing. STR stands for short tandem repeat.
And what were the STR DNA results obtained from testing item 62, Doris Washington's vaginal swabs?
For the results on Doris Washington's vaginal swab, we obtained a profile in the non-sperm fraction, which matched Doris Washington. And in the sperm fraction, we obtained a major male profile.
Now, based on the fact that a major male profile was found in the sperm fraction of Doris Washington's vaginal swabs, can you draw a conclusion about what type of biological material was the source of that male DNA?
It's consistent with originating from sperm.
Did you compare the male DNA profile found in the sperm fraction of Doris Washington's vaginal swabs to any known reference samples?
Yes, we compared it to the reference sample of Darryl Howard.
And what type of sample was that?
It was a buccal swab or an oral swab sample.
And what were the results of the comparison of the male DNA found in the sperm fraction of Doris Washington's vaginal swabs to Mr. Howard's DNA profile?
Mr. Howard is excluded as being a possible contributor of that.
And just to be clear, what is an exclusion?
An exclusion means it is simply not possible that that could be his DNA.
Is that 100% certain?
Yes, it is.
Are you familiar with the CODIS database?
Yes, I am.
And what is it?
The CODIS database is the national database that houses not only reference profiles from either convicted offenders, and some states have arrestee laws, and so any sample that qualifies from either the state or on a national level can be uploaded into the CODIS database. And then when you have a sample from a crime scene, that can be uploaded and compared to that database to determine whether there is any matches in that database.
And who developed this database?
The FBI.
And why was CODIS developed?
To help solve crimes.
And are you familiar with how CODIS hits are obtained?
I am, yes.
And does your lab need to meet certain quality standards or accreditation standards in order to be able to submit samples to the FBI's CODIS database?
Yes, and actually, LabCorp could not actually submit a sample directly to the database. It has to go through a government laboratory. So not only does LabCorp have to meet specific standards for our samples and our profiles to be eligible, but they also have to be reviewed by a government lab or the state lab in this case in order to be uploaded.
And did the North Carolina State Bureau of Investigation agree to review LabCorp's data?
Yes, they did.
And is that after conducting some sort of site review and reviewing all of your technical data?
Yes, they review all of our technical data, our SOPs, our validations, our quality controls, and then they actually review the complete case file and all of the results, including all of the quality samples that are used throughout the testing.
Was the male profile that LabCorp identified in Doris Washington's vaginal swab eligible to be compared in the FBI's CODIS database?
It was, yes.
And did you send the data obtained from DNA testing of Doris Washington's vaginal swabs to the State Bureau of Investigation for review and entry into CODIS?
Yes, we did.
And did you later learn that a male profile, that the male profile that was detected in the sperm fraction of Doris Washington's vaginal swabs had been uploaded into CODIS and that there had been a hit?
Yes, I was aware of that.
And by the way, what does a hit signify?
What a hit signifies is that the male profile that was uploaded matched, there was a potential match found within the CODIS database.
And when you say potential match, is there a procedure for confirming that match?
Yes, there is. There are actually a couple different levels of confirmation. The first level is that the profile of the individual at hit 2 needs to be researched, and they need to ensure that that did actually come from that individual. And then generally a second sample is obtained from the individual at hit 2, and that is run and then compared separately to the evidence.
Your Honor, I'd like to show the witness what's been marked as Defendant's Exhibit 12.
All right.
Ms. Clement, have you seen reports like this before from the State Bureau of Investigation?
Yes, I have.
And what type of report is this?
This is a laboratory report which discusses the results and the testing that was performed on a saliva or buccal swab sample and then compared to the profile that was obtained from LabCorp.
And is this the type of report that experts in your field reasonably rely on?
Yes, it is.
What is the conclusion in this report?
The conclusion is that the partial DNA profile obtained from the vaginal swabs of Doris Washington, which was item 62 as provided by LabCorp, is consistent with a mixture The predominant male profile matched the profile of Jermec Jones.
And having read their conclusion, do you agree that the results that the State Bureau of Investigation obtained confirm that Jermec Jones' profile matched that of the predominant male profile in the sperm fraction of Doris Washington?
Yes, I do.
And what is the statistical calculation associated with that match?
The probability of randomly selecting an unrelated individual with a DNA profile that matches the predominant DNA male profile is approximately 1 in 20,700,000,000 in the North Carolina Black population.
What does that mean?
What that means is that if I were to test the first Black male who walked by, the chances that they would have that same profile is approximately 1 in 20,700,000,000.
So is that a rare profile?
Yes, it's extremely rare.
Did I send you this report earlier this month?
Yes, you did.
And was that the first time you had seen it?
Yes, it is.
I'd move to admit defendants 12 and also 11.
No objection, Your Honor.
All right, it's allowed.
Ms. Clement, based on the data and the DNA results obtained, do you have an opinion to a reasonable degree of scientific certainty as to whether Jermec Jones had sexual contact with Doris Washington?
Since that profile was found on a vaginal swab, which was collected from the vaginal vault, it's consistent with them having sexual encounter.
By the way, going back to your 2010 report, which was marked as Defendants 5, I believe, your report uses the phrase alleles detected. What is an allele?
An allele is simply a scientific name for characteristic. At each of the areas of DNA where we test, there's a variety of characteristics that are found in the population. They're given number designations, and so the allele just means this is what characteristics were actually observed.
And were there any alleles or characteristics detected in Doris Washington's vaginal swabs that did not come from Jermec Jones?
There were 2 areas that we tested where we obtained a third characteristic, but in both of those, the characteristics were consistent with Doris Washington herself.
So the alleles in Doris Washington's vaginal swabs that did not come from Jermec Jones are consistent with Doris Washington?
That's correct.
Now let's move on to Nishonda Washington, the 13-year-old daughter. Directing your attention to page 1 of the inventory, I believe that's marked as defendants
9.
9, yeah. Page 1, what items are listed on that page?
The items listed on this page were LabCorp item number 59, which was the vaginal smear, and LabCorp item 60, which was the rectal smear.
Of which victim?
I'm sorry, of Nishonda.
Now, what is a smear as opposed to a swab in a sexual assault kit?
A smear is a slide that has cellular material smeared on it.
What's the purpose of doing that?
Generally, it is to use it at a later date to microscopically search for spermatozoa on it.
Your Honor, I'd like to show the witness what's been marked as defendants 13. Do you recognize this document?
Yes, I do.
And what is it?
These are photocopies of the actual smears that were submitted to LabCorp for analysis.
And where were these photocopies made?
They were made at LabCorp.
And were they made in the ordinary course of business at LabCorp?
Yes, they were.
And what is depicted in these photocopies?
On the first page, which is stamped at the bottom, ending in 13, is a photocopy of the 2 vaginal smears, which was LabCorp item 59. And on the bottom of what's bait stamped ending in 14, on the second page of Defendant's Exhibit 13 is a photocopy of the rectal smears.
And do these photocopies accurately depict the vaginal and rectal smear slides of Nishonda Washington labeled LabCorp 59 and 60 in substantially the same condition they were in when you received them from the State Bureau of Investigation?
Yes.
Now, did LabCorp examine the vaginal and rectal smears of Nishonda Washington?
Yes, we did.
Now, you previously identified SBI's bench notes as defendant's exhibit, I believe that was 11, yes.
Yes.
Turning your attention to Bates number 748 at the top. What items are described on this page?
On this page, it describes the sexual assault kit from Nishonda Washington, and the items that are described are the vaginal smears and vaginal swabs.
And what does it say about her vaginal smears at the bottom?
On the vaginal smear, there was sperm found, and it indicates that there were intact sperm.
Intact sperm.
Yes.
What does that mean?
Intact sperm indicates that not only the head of the sperm was there, but also the tail of the sperm.
What, if anything, does that tell you about when the sperm was deposited?
Generally, in the forensic community, the tails are very fragile and tend to break off pretty quickly. It's been my experience in analyzing sexual assault kits that you don't tend to see intact sperm if the semen has been deposited more than about 24 hours is a stretch. Usually usually it's less than that.
So in this case, given that it says sperm was found and it was intact, are you saying that the sperm was deposited less than 24 hours from the time these swabs were collected?
That would be my opinion, yes.
Was a differential extraction performed on the vaginal and rectal smears of Nishonda Washington?
Yes.
And after that differential extraction, what analysis was conducted?
We conducted the same PCR testing for STRs that we did on Doris Washington's samples.
What results were obtained from STR testing items 59 and 60 Nishonda Washington's vaginal and rectal smears?
We obtained partial profiles in both the sperm fraction of the vaginal as well as sperm fraction of the rectal smears. The male profile in both of those samples appear to have originated from the same individual, and Darryl Howard was excluded as the source of that.
Did you compare the male DNA in Nishonda Washington's rectal and vaginal smears to the male DNA found in Doris Washington's vaginal swabs?
Yes.
And what were the results of that comparison?
The DNA from the sperm fractions of the vaginal and rectal smears in Nishonda was from a different male than the DNA from the sperm fraction of the vaginal swabs from Doris Washington.
So you got one male profile in Doris Washington's vaginal swabs. You have a second different male profile in Nishonda Washington's vaginal and rectal smears, and neither is Darryl Howard.
That's correct.
And the male DNA profile found in Doris's vaginal swab was identified to be that of Jermec Jones, correct?
That's correct.
Was any of Jermec Jones's DNA found in Nishonda Washington's vaginal smears?
No.
Was any of Jermec Jones's DNA found in Nishonda Washington's rectal smears?
No.
Was any of Jermec Jones's sperm, biological fluid, DNA found in any of the evidence samples tested from Nishonda Washington?
No.
But there was sperm found in Nishonda Washington's vaginal and rectal smears. There was intact sperm with tails and heads still on it, intact sperm deposited prior to her death, intact sperm that did not come from Jermec Jones. Is that right?
On Nishonda, Washington, that's correct, yes.
So let me ask you this. If Jermek Jones were to say that he had sex with Nishonda and somehow his sperm transferred from Nishonda's anus to her mother Doris's vagina, scientifically speaking, could that happen? Could Jermek Jones have sexual contact with Nishonda, erase all traces of his DNA in Nishonda, and somehow transfer his sperm to her mother's vagina without ever touching the mother?
I can never say it's impossible, but the likelihood is infinitesimally small.
Infinitesimally small.
Small, yes. There's nothing to indicate that Jermek Jones was anywhere near Nishonda, Washington.
Now, was this male profile detected in Nishonda Washington's vaginal and rectal smears eligible for comparison to the FBI's CODIS database?
No, it was not.
Why
It was
not?
too partial. There were not sufficient numbers of areas where we obtained results for it to be uploaded.
Now, even though that profile was partial and didn't have sufficient markers to be uploaded, can it still be used for comparison purposes if, let's say, you were to receive a DNA sample from a known individual?
Yes. It's not.
Your Honor, I'd like to show the witness what's been marked as defendants 14. Ms. Clement, do you recognize this document?
Yes, I do.
And what is it?
It is a letter which outlines the statistics for the partial profile that was obtained from the sperm fraction of the vaginal smear and sperm fraction of the rectal smear of Nishonda, Washington.
Now, it says Cellmark Forensics at the top. Was this prepared while you were at Cellmark?
Yes, this was prepared while I was working in Dallas at Cellmark Forensics.
But it's based on the testing that was conducted while you were at LabCorp?
That's correct.
Okay. Now, what is the purpose of assigning a statistic?
A statistic simply shows how common or rare a particular profile is in the general population.
So you're trying to assign a weight to this match?
That's correct.
Now, did you obtain a statistic?
I did calculate a statistic on the partial profile from both the vaginal smear and the rectal smear.
And what is that statistic?
For the vaginal smear, the statistic was 1 in approximately 3,791 in the African American population, 1 in 4,780 for the Caucasian population, and for the Southwestern Hispanic population is 1 in 20,810, and the Southeastern Hispanic population 1 in 14,743.
And yes,
I'm sorry.
Keep going.
I was going to say for the rectal smear, the probability of randomly selecting an unrelated individual in the African American population was approximately 1 in 6,489, 1 in 8,823 for the Caucasian population, 1 in 40,150 for the Southwestern Hispanic population, and 1 in 43,410 for the Southeastern Hispanic population.
And does this letter accurately and correctly reflect the results obtained in calculating a statistic on the partial male profile obtained from Nishonda's rectal and vaginal smears?
Yes, it does.
So let me ask you this. If the state were to collect DNA samples from 1 or 5 or 10 potential suspects that were brought to their attention as potential donors of the sperm in Nishonda, Washington, could their DNA samples be compared to the male DNA found in Nishonda, Washington's vaginal and rectal smears?
Yes, it could.
And were the state to make an effort to conduct that type of investigation, and were there a potential match to an alternate, we could assign a statistical significance to that match based on this statistic?
That's correct.
Your Honor, I'd like to show the witness what's been marked as defendants 15.
Your Honor, if we can have a moment to go through this, it's pretty, Your Honor, if we may have a moment, it's pretty voluminous.
These documents were produced to the state as beta.
I understand, we're just going to look through them.
All right, counsel, why don't we do this, because I've got to do a number of things unrelated to this case. I was going to break at 12:30 for lunch anyway. Why don't we go ahead and go to lunch, and we'll be back at 2:30, Mr. Deputy.
Yes, Your Honor.
Can I just finish?
So we're done there.
2:30. Yeah.
We'll stand recess till 2:30.
Sir.